Hello, my name is John Connors, and I will be presenting today about transgender rights in the time period of 1993 to 2015. The first subject area I will be discussing is discrimination in the workplace. Before 1993, transgender employees could be fired and denied employment based on their gender orientation in the public and private sector. This was first addressed in 1993 at the state level when Minnesota amended its Human Rights Act, expressly forbidding employment discrimination against people based on their sexuality, which included gender orientation. This was the first legislation of its kind. In 2001, 8 years later, Rhode Island followed suit, setting off a domino effect that 22 states would join in on before 2012. In 2012, a police detective transitioning from male to female would be denied a position at the Bureau of Alcohol, Tobacco, and Firearms. This would lead to a lawsuit that would result in the United States Equal Employment Opportunity Commission extending protection to transgendered applicants and employees as part of Title VII of the 1964 Civil Rights Act. Transgendered people were also denied health insurance. Their orientation was deemed a pre-existing condition by insurance companies. They were denied medical treatments vital to their health and mental well-being. These treatments ranged from hormone therapy and psychological counseling to gender reassignment surgery and outpatient care. In 2005, California would pass the Insurance Gender Non-Discrimination Act. This act would outlaw denial of coverage based on gender orientation within the state. In 2010, the Obama administration would extend these protections nationwide on the federal level as part of the Patient's Bill of Rights, a provision of the Affordable Care Act. This bill would force any medical facility that got federal funding to provide care to transgender patients and protect them from harassment or segregation from the general population. This would also prohibit insurance providers from denying coverage to transgender people on the basis of their gender orientation being a pre-existing condition. However, the act would not mandate insurers to cover gender reassignment surgery, an issue that many transgender activists would fight to change to the modern day. Next, the transgender rights would be within the criminal justice system. In 2009, Alan Andrade would murder Angie Sabata, a transgendered woman. The resulting criminal case, Colorado v. Andrade, would be the first time a court successfully prosecuted a defendant for hate crimes for acts against a transgender person. This would serve as precedent for criminal proceedings nationwide, unofficially establishing transgender people as a protected class in the eyes of the law. The same year, the federal government would pass the Matthew Shepard and James Byrd Jr. Hate Crime Prevention Act. This would establish harsh penalties for people committing crimes against transgender people. The act would also fund additional resources for state and local law enforcement officers to help them combat crime against transgendered victims. One unlikely area that has sparked much debate in regard to transgender rights has been access to restrooms and locker room facilities. In 2013, California passed the School Success and Opportunity Act. This was a bill that permitted transgender public school students to use locker rooms and restroom facilities statewide in accordance with their gender orientation, as well as participate in sports teams that correspond to their gender orientation. While the federal government has yet to respond or pass any legislation like this, several state-level legislators have proposed legislation that would criminalize transgender use of bathrooms. One state representative in Florida sponsored a bill that would make use of bathrooms and locker room facilities that did not correspond with one's gender identity at birth and make that a criminal offense liable for high fines and time in prison. Another state representative in Texas put forward a proposal that would charge anyone using a restroom or locker room facility that did not correspond to their DNA's chromosomes with a felony. While these bills have yet to be put into law, they could put back transgender rights in these states by a great deal. While the advances in the last 2 decades have advanced gender rights greatly, transgender activists agree that a lot still needs to be done. In 2013, Senator Merkley, a Democrat from Oregon, proposed the Employment Non-Discrimination Act, a bill that would outlaw discrimination against transgender employees and applicants in both the public and private sectors. In 2015, Representative Cicilline, a Democrat from Rhode Island, introduced the Equality Act, a comprehensive bill that would outlaw employment discrimination as well as outlaw criminalizing transgender gendered use of bathroom and locker facilities by states. If passed, these bills would extend a lot of the aforementioned rights of transgender citizens on a national level.
And remove states' abilities to pass legislation criminalizing transgender access to locker room and restroom facilities. If passed, these bills would do a great deal to advance transgender rights. And that is all